And another against Zinnia Rolle.
Yes, Miss Wright.
Good morning, my lords.
It's afternoon here, but good morning to you too.
Good afternoon. Thank you for that, my lord.
Can I just check? You can hear all right?
I can hear you.
Thank you. And Miss Pyfron?
I can hear you. Good afternoon, my lords.
Excellent. Well, that all seems to be working. Now we have a very short case management hearing about where we go in this appeal. So we'll hear from Miss Wright.
Thank you, my lord. Thank you very much for the opportunity to be heard. I represent the appellant, and for the purpose of this case management, I was asked to address the panel on whether or not the grounds of appeal upon which the appellant intends to rely fall foul of the decision of DV versus Roy. My lord, I have laid over arguments,
Yes.
and I'm not.
We've got your written submissions.
Yes, my lord.
Miss Wright, thank you very much. So this
I
is
wasn't
really your
sure-
opportunity to add to those and or comment on the submissions which we've received in writing from your opponent.
Okay. And I wasn't sure if there was anything additional by way of housekeeping you wanted me to do, or should I just get right into my,
Can I just ask one question? Are your grounds of appeal formulated anywhere, or do we just find them in your submissions that you filed? Is there any other statement of them?
They are laid out in my submissions, my lord, but they are also laid out in the notice of appeal that was filed in the Privy Council in the attachment. But I noted as I was going through in preparation today that the normal attachment was not included in the key bundles. But
No, that would explain why I couldn't find it in the bundle.
Yes, my lord, but they are laid out verbatim in my submissions. My apologies.
Okay, so we can just take it from your submission, that's fine.
Thank you, my lord. My lord, so there are only two grounds, and the first ground deals in principle with the amount of the judgment that was entered in the court below. And without going through the grounds, because they're laid out in the submission, to the issue of whether or not the board should hear it, I say resoundingly yes, my lord, for two reasons. The issues that arise in ground number one do not amount to concurrent findings of facts of two courts. It is my understanding that the principle, for the principle to apply, there must be a concurrent finding of fact in two of the courts below. And my lord, it is my respectful submission that simply upholding a judgment of the lower court without considering and discussing and ruling on the issues before the Court of Appeal does not constitute a finding of a concurrent finding. And my lord,
The problem here, I think, the objection is not that there are concurrent findings, but it's the opposite objection, that you've never raised the point before.
my lord, with respect to both grounds, it was my understanding that I had to address both. So I'll go quickly now then to whether or not this issue regarding the judgment was raised before. My lord, the issue is really regarding the amount of the judgment, and it encompasses all of my arguments which would have led the court below to calculate, or the plaintiff in the Supreme Court to calculate the amount of the judgment. It is our submission that in our supplemental notice of appeal, it was raised, the amount of the judgment as a ground of appeal was raised in at least three instances in the grounds, at grounds 2, 5, and 6. And more specifically, my lords, in
Sorry,
the arguments
which
that,
document are you referring to?
my apologies, my lord, it would be in the key documents bundle at tab 5.
Yeah.
That's the notice of appeal that we appeared before His Lordship in the Court of Appeal after the ruling in the Supreme Court. So we spoke directly to the amount of the judgment in grounds 5 and 6, and we also respectfully submit, my lords, that at ground 2, that also opens the door for the respondent to present its arguments on the amount of the judgment.
Well, hold on.
And you will see, my lord,
Could I just ask you to
in the
pause?
appellant's arguments before the Court of Appeal,
Well-
at tab 6, it would be on page 079.
Yeah, you're ahead of me, Ms. Wright. Can I
sorry,
can
my
I just
lord.
ask you to go to your tab 5? That's the supplementary amended notice of appeal, which I think is to the Court of Appeal, isn't it?
That is correct, my lord.
You said it was grounds 2, 5, and 6. Now, I have grounds 2 and 5 start on page 34.
Correct.
And 2 appears to be a perfectly general assertion that the judge ignored relevant evidence.
Yes, my lord.
5, the ground in 5 appears to be that there was no credible receipt voucher or proof that the sum of 36,000 odd was paid to the first respondent.
Sorry.
And the ground 6 was apparently, again, is a perfectly general ground, simply saying, well, she was wrong in law and fact without giving a reason awarding the sum she awarded. That's the 3,143.
Yes, my lord.
Well, now, I'm not quite sure how grounds 2 and 5 help you, but I'm assuming that the amount in question in 6 is the interest amount.
No, it's a separate sum.
No, it's not,
It's
my
a
lord.
separate sum. It's not the amount you're now raising.
Yes, see, my lord, at ground 5, the entirety of ground 5 speaks to the amount of the judgment.
Well, it does, but the ground is that what you're complaining about, the reason why you say she was wrong, is that there was no credible receipt voucher or proof that sum was of payment of the sum in the first place.
I understand that, my lord. It is my respectful submission that based on the wording of ground 5 and also the submissions made before His Lordship's in the Court of Appeal, which, if you would turn with me, please, to page 079 at paragraph 54, we flushed that out and full arguments were put before the court. The respondent also failed to prove the amount of 64,000. Her ladyship simply entered judgment on the amount pleaded without the respondent verifying her calculation, without the respondent proving she was entitled to interest past 3 years or at all, without proving the rate of interest she used in the calculations contained in the statement of claim. And those arguments were advanced in the Court of Appeal, and His Lordships never took it on in their ruling.
Well, did you have a case about what amount of interest was, what rate of interest was appropriate?
Well, my lord, the rate of, based on the contract that the courts below held to be valid, the interest was to be 10% over 3 years.
10%, 10% in total or 10% per annum?
10% per annum.
Right.
And after the 3 years, if that amount wasn't paid, then the defendant would have been in breach of that contract. So the contractual rate of interest was to have stopped. But the plaintiff continued to add interest up to the time when the statement of claim was filed. But even if that were not the case, my lord, the judgment that was entered in the Supreme Court spoke specifically to what the plaintiff was entitled. And that can be found at tab, and this is extremely important, my lord, at tab 3. And it's actually page 029 of the key documents bundle.
Sorry,
You will see,
Page
yes, my lord, 029.
29, that's in my tab 4.
No, I think it's at the end.
No, it's at the end of tab 3.
I think my tab 4 has been inserted in the wrong place. Yes, I
Right.
understand. I've got it. Thank you.
Thank you, my lord. You will see that her ladyship, right, if you go right to the middle of that paragraph, if I may, just for the sake of time. She said $64,000 on the recovery of $40,000 with interest calculated at 10% up to the 23rd of April 2010. My lord, the interest which was calculated to bring that amount to 64,000 was calculated over 6 years. If we were to follow the letter of the judgment, the plaintiff would only have been entitled to calculate interest for a period of 3 days.
But that's an obvious mistake, isn't it?
Well, it is. I think it would fit squarely within the category of a blunder or error,
Yes.
my lord.
It's an obvious error, isn't it? It must mean from. It must mean from the 23rd. It must mean
I
from
respectfully cannot agree with that,
Sorry?
but I'm in the court's hand.
Well, it simply doesn't make sense otherwise, does it?
It absolutely does not, my lord. But in addition to that, if it were to mean from the 23rd of April, then we've opened another can of worms. Because if the judgment in the court below were to be accepted, the funds which are the subject of this amount were not paid in total on the 23rd of April,
I see.
2010. So the reason why we say that this judgment is unsafe for a number of reasons, but the principal one is there was never any calculation, verification, determination on whether or not the amount that was pleaded, whether the plaintiff was entitled to it.
Well, did you raise, what I'd like to ask is whether you raised any argument before the judge about the amount.
I absolutely, you mean in the court of appeal?
No, I mean
Sorry,
before the judge, in the Supreme Court.
My lord, respectfully, I was not counsel of record, but I can answer that based on the pleadings that I have read. The plaintiff was put to strict proof of their claim. And even on a default judgment where there's no one on the other side, the court, a plaintiff who asserts that they are entitled, particularly to a liquidated sum representing damages, must still prove it. And in every instance where the plaintiff alleged that certain liquidated damages were owed, the defendant in their pleadings over and repeatedly put the plaintiff to strict proof.
So
we respect.
Yes, I take it that, Mr. Daniel Saunders was your predecessor. He was counsel for the defendants at the trial.
Donald Saunders.
Donald Saunders. And
yes.
he made no submissions on this point. Is that correct?
I cannot say whether or not that's correct, my lord.
Because when you were addressing the Court of Appeal,
yes,
the President asked you where in the closing submissions on behalf of the defendants this point was raised, and I think the answer is nowhere, isn't it?
My lord, to that I also said to his lordships in the Court of Appeal that if the plaintiff has a legal obligation to prove his or her claim, the fact that they did not, and the fact that the court may not have been addressed, the court still has an obligation to require that the plaintiff before it meets its legal burden of proof. And so I believed, and I respectfully submit to your lordships today, that the appellant was well within its right to challenge the judgment on the amount if, based on the ruling in the Supreme Court, there is no evidence that her ladyship addressed her mind to whether or not the liquidated damages were proven. My lords, I would submit here emphatically that that was a viable ground upon which to seek to impugn the integrity of her ladyship's judgment in the court below, in the Supreme Court. But the fact is, my lords, we did raise it before his lordships. We had full arguments on it. And when we applied for conditional leave to appeal, the issue that as to whether or not his lordships addressed it in their ruling was brought to the center. And his lordships in the Court of Appeal wrapped up my position in speaking with my learned friend opposite by saying, well, this is what Mrs. Wright is saying, and it's in the transcript that is at tab 13 of the key documents bundle. You will see clearly that his lordships did understand that my...
Where do we find that? Sorry, can you give us the page?
Absolutely, my lord.
Thank you.
My lord, would you turn with me, please, to page 262?
262.
Yes, my lords.
Okay.
At lines 9 through 14.
This is at the stage of leave to appeal to the Privy Council.
Conditional leave, my lord, yes.
Yeah, not at the stage of the Court of Appeal hearing itself. I thought you were suggesting there was argument about this point before the Court of Appeal on the appeal itself.
Okay, I can take you there, my lord. I can take you there. My lord, before I turn away from that page that you were on, lines 9 through 14 is the president of the Court of Appeal indicating that my argument for conditional leave was that, listen, and these are his words, listen, you did not deal with the proper calculation of the amount of the judgment, and therefore she should be able to appeal, meaning me, my lords, should be able to appeal to the Privy Council on the basis that the amount of the judgment was wrongly calculated and that we did not address that issue in our judgment. So,
well, that's your argument, to which the answer was the same as the one given here, that you'd never raised the point.
I see that immediately thereafter, my lord. But my lord, the pleadings stand for themselves. And if there is an express denial of a fact, particularly as it deals with liquidated damages, the fact that the court, nothing absolves the court from requiring a plaintiff to prove their claim.
Well, no particular proof is required. It's a matter of legal argument what interest rate is going to be awarded. If you want to raise an argument, And you could have raised the argument that you've only got the contract for 3 years and after that it should be some different rate. But you didn't argue that.
My lord.
Well, not you, but your predecessor didn't argue that.
My lord, what you just said is half of what actually happened, because I had indicated when I started that the argument was about the total amount of the judgment. We also argued that the calculation of the amount owed, that the basis for the judgment was not vouched or proved. Not only was it not vouched or proved, which is not a legal argument, my lord, it is a matter of fact.
What's the fact that needs to be proved? What is the fact?
That the defendant received or was paid the sum that the plaintiff was claiming. And in fact, the judge in the Supreme Court made an incorrect statement of fact that the defendant had accepted. And that was challenged by his lordships. My learned friend was challenged by his lordships in the Court of Appeal that in fact was not correct. And I can take you there in the transcripts, my lord.
I'm sorry to interrupt you yet again, Ms. Wright, but the point I think you're now making, that there was no evidence that this sum had ever been paid, is not a point that you raise in your ground of appeal to this board.
This is your ground that we're dealing with at the moment is about how the interest is calculated.
It's a bit broader than that, my lord, respectfully.
Can I see if
it's about the amount that includes the calculation of interest, and it includes what the original debt is. If you look at A of my ground one, that she was wrong in law in limiting that they were wrong in law in limiting the decision as to findings of fact to the execution of the agreement and disregarding the critical findings of fact related to the amount of interest. And the amount of interest, respectfully, my lords, must include the original sum and the calculation of interest.
Yes, but can I just try and help on this?
Yes, my lord.
This is a contractual rate of interest, so that the amount is presumably a pure matter of mathematical calculation rather than proof of facts. Subject to this, I thought your point was not that you could raise again before this board the question whether the sum was ever paid over, but when it was paid over, or when all of it was paid over. And I'm assuming you mean that interest would only run from when the sum was paid over. Have I understood that correctly?
You did, my lord, understand that correctly. And I said that against the backdrop that the court below did make a finding that the contract was should be upheld. So I was not going to come here before his lordships to argue that, at least not under these grounds. No. But if you take the findings of fact, the concurrent findings of fact of the court above, of the Court of Appeal and the Supreme Court, the one thing that you can say from the judgment that both courts considered and ruled on, wrongly in my view, but that's not why I'm here, is that the contract was enforceable. So my statement to you with regard to when the interest was to run was against that backdrop, my lord. But even when you speak to contractual, what was due under the contract, if you are to, and I would like to underscore this point, if you were to take the simple 10% per annum over 3 years and add it to the judgment debt, you still would not come up with what the plaintiff claimed was owed as at the time of the breach.
Why? I think you're assuming there that the rate of interest was a simple rate of interest. But the contract says that it's a rate of interest of 10% per annum calculated annually, which only means that it's compound with annual rests.
My lord,
Well, then we get a different...
If I have to assume that, then that means that that was a matter of fact that the court ought to have determined. And I do not believe that there's sufficient terminology in the contract for the converse to be assumed that it was compounded.
But this
And
is,
the way that
with all respect, this hasn't appeared as an argument at all in this case before now.
Yes, it has, my lord.
What, an argument as to whether it's simple or compound interest?
Oh, sorry. You are correct. It hasn't.
Because the problem is that no argument was raised before the trial judge in relation to the amount that was claimed.
Yeah, right.
My lord, is it not sufficient to put the plaintiff in civil proceedings to strict proof and ask the court to hold them to the civil standard?
Well, as my lord has said, the judge held that the contract was made, so that was a question of fact. Once it's accepted that the contract was made, there is no more fact to be found. There might be arguments about dates of payment, but I don't think that was raised before the judge. Nothing was raised before the judge.
My lord,
The whole trial was about whether these contracts had been forged or not. That was the focus of the trial. If they had been forged, then your clients would have the case against them dismissed. But if they weren't forged, then your clients failed. They could have raised arguments about the precise calculation of the sum claimed against them, but as I understand it, they didn't. And I think you accept they didn't, but you say that nonetheless it was for the claimant to explain to the judge exactly how the sum was calculated.
And the judge, having not done so, created a ground of appeal. But you did make a statement, my lord, and if you would indulge me, I'd just like to address it quickly. When you speak about once the contract, it's determined that the contract has been made, it's just a matter of a calculation. So even if we were to, my argument before the Court of Appeal has been, listen, we need to look and see how this matter how this judgment was calculated. Because if you were to just go on the 10% per annum, simple, which it appears the plaintiff attempted to do, you would not arrive at the amount that she claimed was due at the time of breach. The $64,000 was the amount that she was claimed was due at the time she commenced the action.
But was interest awarded on... The interest was calculated up to what date? On any... There was a large period on any view for which your client has never had to pay interest, is that right? Total judgment was interest payable on top of the 64,000 for any period between the issue of the writ and the judgment, the giving of judgment?
No, sir.
No, so you've got 6 years interest-free.
Oh, sorry, I misunderstood you.
Yeah.
The 64,000
Yes.
is interest up to the filing of the writ.
Okay. And what about after that?
While the matter was being determined, my lord,
Yes.
nothing was paid, and nothing was paid while it was under appeal.
So no, not question of pay, but interest, was any award of interest made for the period between the writ and judgment? I mean, once there's a judgment, there'll be interest on the judgment at the judgment rate.
Absolutely not, sir.
No, so your client has got 6 years interest-free on this money between the writ and the judgment. Even if the amount at the writ was a bit over-calculated, you've had 6 years when interest could have been awarded. So I would think if we're going to look at the question of interest on this appeal, we should probably look at the whole question, including whether interest should have been awarded for the period between the writ and the judgment, at 10% maybe, or some other rate.
Well, you see, my lord, that is the issue that we have. because if the judgment itself, if the judgment itself was entered for too much, then that judgment ought to be set aside. So respectfully, my lords, I do not see that the defendant who is defending himself against irregular or improper judgment should be faced with the penalty of additional interest when it is completely within his right to defend a bad judgment.
Well, Ms. Wright, we've heard you for half an hour. I entirely accept that a lot of that has been your response to the panel's questions.
Does she want to say anything about the concurrent findings?
Yeah,
Yes, I mean, thus far we've really concentrated on what I will loosely call the interest calculation point. Is there anything you want to add to your written submissions about the concurrent findings of fact point, that is, whether or not there was a forgery?
That is not a part of the grounds, my lord. It was, my grounds related to the other finding of fact which his lordships in the Court of Appeal failed to address, and which was the amount of the judgment was wrong.
Well, what's your ground two?
We've heard you about that.
What's your ground two?
Okay, my lord, on before we get to ground two, just very quickly, you asked if there was anything additional I wanted to add. I just wanted to say that the fact that the court did not consider the point supports my argument that they are not concurrent findings of fact. And I'll go on to number two. Even if the court ruled that there was concurrent finding of fact, we still submit at paragraph 14, paragraphs 14 through to 21 of our submissions that
yes,
this is a proper case for the court to depart
those
from
are
its
your
practice.
grounds for
And
saying.
I would underscore paragraphs 18, 19, 20, 21, 22, and 23, dealing with the rate of the arguments regarding the amount of the judgment. My lord, it is fundamental to civil proceedings that a judgment that is entered for too much is a bad judgment and ought to be set aside. But on to ground two, my lords. On to ground two, we say that this ground also is not a matter of a concurrent finding of fact. The issue of delay, my lord, only arose in the Court of Appeal. It was the justice below took over 4 years to deliver this judgment. So that issue would never have come up in the court below. The first instance that we had to challenge that was in the Court of Appeal. And therefore, it cannot be considered a concurrent finding of fact within the principles set out in Devian Roy.
I understand.
My lord, the appellant would really want to have an opportunity to have the issue which his lordships below, my lord, if you look at my page, the last page of my submissions, and just the language of his lordships themselves with regard to the delay, that it was lamentable, incredulous, inexcusable, particularly egregious, and he goes on. The question as to whether or not their lordships were correct in saying that there is no justification for this court not to depart from the judge's determination is wide open for another court to determine. Yes, because the question would be how late is too late? Ms. Wright, we all know that justice delayed is justice denied.
We understand the point you're making.
All right, my lord,
I think we now have to ask you to draw your submissions to a close. This is only a 1 hour hearing, and you
fair enough, my lord.
You put in very full written submissions. Before we hear from Ms. Pyfron, We will very briefly retire and consider where we've got to. Well, thank you, Ms. Wright. Ms. Pyfron, we don't need to trouble you. The board has made up its mind after hearing from Ms. Wright, and Lord Leggett will explain the board's ruling on this case management hearing.
Thank you, my lords.
This case management hearing has been held to decide whether the board should entertain this appeal or whether to do so would be contrary to settled practice of the board. The underlying decision is a judgment for $64,000 on a contractual claim by the respondent for repayment of money paid under 2 written agreements. The defence was that the agreements sued upon were never in fact made, and that the signature of the first defendant on the agreements had been forged. That raised a straightforward factual dispute on which the judge heard oral evidence. She found the evidence of the first defendant and the witness called by the defendants to be incredible and rejected the forgery allegation. There was no argument at the trial specifically directed to the amount claimed by the plaintiff, and judgment was given for the sum of $64,000 that I have mentioned, which was said to constitute the principal sum of $40,000 with, quote, interest calculated at 10% up to 23rd April 2010. It appears to the board that the words up to must be a typographical error, because 23rd April 2010 was the date of the second agreement and must have been intended to refer to the date from which interest ran. The writ was issued in April 2015, some 5 years later, and the sum of $24,000 awarded as interest must be understood to relate to the period between the date of the second agreement, 23rd April 2010, and the date of issue of the writ. It is apparent that no interest was awarded for the period from the date of the writ and the date when judgment was given. That date was 6 December 2021, and on the defendant's appeal to the Court of Appeal, the main ground of appeal relied on was a complaint that there had been inordinate delay between the hearing at which evidence had been taken in August 2017 and the eventual handing down of judgment in December 2021. That was a period of over 4 years, extraordinary by any judicial standard. The Court of Appeal considered that argument that the delay made the judgment unreliable and unsafe. They, however, rejected it. They did so on the basis that, however egregious and culpable the delay was, it did not prevent the judge from properly evaluating the evidence and making the finding that was determinative of the case. The result is that on the issue of whether the agreements sued upon were genuine or forged, there are concurrent findings of fact by the two courts below. It is the settled practice of the board not to depart from such concurrent findings of fact, save in exceptional circumstances. That practice was authoritatively stated in the case of Devi against Roy, 1946 Appeal Cases 508, and has been consistently applied by the board ever since. There are two grounds of appeal against the decision of the Court of Appeal which the defendants now seek to advance before the board. It is convenient to take first ground 2 of the proposed appeal. That is an argument that the issue of delay arose only for the first time in the Court of Appeal, and the challenge to the judge's finding on the basis of that delay cannot, for that reason, be regarded as involving concurrent findings of fact, because necessarily the judge made no finding about the effect of delay on her own judgment. The board regards that argument as misconceived. The contention that the judge's findings of fact were unsafe and unreliable because of the egregious delay which occurred is no different in principle from any other argument seeking to challenge, for one reason or another, the reliability or accuracy of the judge's findings of fact. That argument having been rejected by the Court of Appeal and the judge's findings upheld by the Court of Appeal, there are now before the board concurrent findings of fact on the essential question of whether the agreement was genuine or forged, and no exceptional circumstances has been shown which would justify the board from departing from its settled practice not to disturb such findings. Ground 2 of the proposed appeal is therefore directly contrary to the practice recognised in Devi and Roy and cannot properly be entertained. The argument which Miss Wright has put at the forefront of her able submissions this afternoon seeks to raise an issue about the quantification of the claim, and in particular about the amount of interest included in the judgment sum. It is common ground that that point does not raise a question of concurrent findings of fact. Indeed, there are no findings of fact on the point in the courts below. The reason for that, says the respondent to the appeal, is that this argument violates another settled practice of the board, which is not to allow new points to be advanced which have not been argued or ruled upon in the courts below. As was stated in Ryan Cox against Cox, 2019 UKPC 32 at para 11, quote, "It is not the practice of the board, save in very exceptional circumstances, to allow a new point of law to be argued without the benefit of judgments upon it in the courts below, even where all the facts relevant to the new point have been established in evidence or are undisputed." Miss Wright sought to persuade us, first, that the point which she seeks to argue is not a pure point of law, but involves a question of fact, which is not the subject of concurrent findings. The board cannot accept that. There was no relevant dispute of fact at the trial that affects this point. There was no dispute, so far as the board can discern, about the payment of the sum of $40,000. The fundamental question is whether it was paid under a genuine or a forged agreement. The point is therefore therefore a question of law about how interest should be calculated. In particular, it could have raised issues about whether and for what period interest should be awarded at the contract rate of 10% in circumstances where, as Ms. Wright points out, the contract provided for 10% per annum interest to be awarded for the contractual period of 3 years, but said nothing about the award of interest after that. The board considers, however, that the time to raise any such argument, if it was to be raised, was at the trial, or failing that, before the Court of Appeal. Ms. Wright says that the point was raised before the Court of Appeal, but the board is not satisfied that it was raised properly or sufficiently for that submission to be borne out. We were taken to the grounds of appeal, where Ms. Wright sought in particular to rely on grounds 5 and 6. Ground 5 states, quote, "The learned judge in the court below erred in law and or in fact when she ordered that the appellant pay the value of the respondent's filed claim in the amounts of $64,000 on the recovery of $40,000 with interest calculated at 10% up to 23 April 2010 in the absence of any credible receipt, voucher or proof that the sum of $36,000 odd was paid to the first respondent." And ground 6 then continues that the learned judge erred in law and in fact when she, without any evidence and without giving a reason, awarded the sum of $3,143 to the respondent. Neither of those grounds, however, directly takes issue with the calculation of interest. The first of those raises a question about the absence of a credible receipt, voucher or proof, and the second is simply a denial that there was evidence to support the award of sum of $3,000. It is right to say that in the skeleton argument of the respondent before the Court of Appeal at paragraph 54, there is an assertion that there was failure to prove the amount of $64,000 and that the judge had entered judgment without there being proof that there was an entitlement to interest. But the board does not consider that that bare reference to interest was sufficient to properly to engage argument on the point in the Court of Appeal. And Ms. Wright has not taken the board to any entry in the transcript of the oral hearing before the Court of Appeal, which indicates that the point was ever raised in the course of oral argument. The first time that it was properly raised in the Court of Appeal, so far as the board can discern, was after the Court of Appeal had given its decision upholding the judgment, when permission was sought to appeal to the Privy Council. And it was at that hearing that Ms. Wright sought to introduce the argument disputing the calculation of interest. In those circumstances, the board considers that it would not be right to allow the appellants on this second appeal to introduce argument about interest, raising questions on which neither court below has been asked to pronounce or has pronounced. In the circumstances, the board has not found it necessary to call upon counsel for the respondent. The board is satisfied that the grounds of appeal are not ones which the board should properly entertain, and the appeal should therefore be dismissed at this stage without proceeding to a full hearing.
The court is now adjourned.